Hi folks, welcome back to our channel SQE1 window, and if you are joining us for the first time, hit the subscribe button because today we are trying to learn the most important part of criminal law, homicide and non-fatal offences. So it is very important to understand that how homicide works, murder, manslaughter and rest of it, and non-fatal offences like assault and rest of it like GBH and all. We will talk about it today. So what is homicide? What exactly it is? Simply put, homicide is the unlawful killing of other human. So, but there is it's not that simple. It's there are different types of it. So here is where it gets really important. The law does not treat all killings the same way. There is a crucial distinction between murder and manslaughter, and this distinction is not just academic. It's a profound sentencing, as there are profound sentencing aspects around these classifications. So murder attracts a mandatory life sentence. Let me say that again, mandatory. At that point, the judge has no discretion. If you are convicted or someone is convicted of murder in England and Wales, they are getting life imprisonment. This reflects the fact that murder is considered the absolute most serious criminal offense in our legal system. Manslaughter, on the other hand, carries discretionary sentencing. This means the judge can tailor the punishment to fit the specific circumstances of the case and the culpability of the offender. So at that point, you could get anything, or the person who has committed a murder can get anything from a suspending sentence in exceptional cases to life imprisonment, depending on the facts of the case. This flexibility is important because manslaughter covers a really wide range of scenarios, from a single punch that goes tragically wrong to dangerous driving causing death to killing where there are significant mitigating circumstances, all of them. So what is murder? So code definition of murder is unlawful killing of a human being under the king's peace with intent to kill or cause grievous bodily harm. So now a couple of things to notice here. First, murder is a common law offense. There is no murder act that defines it. This definition comes from centuries of judicial decisions going back to Sir Edward Coke, at that point in 17th century, and remarkably it's been incredibly stable over those centuries. So let's break down the component. You need an unlawful killing. So it's not justified by self-defense or something. You need causation. The defendant's action must have caused the death. The victim must be a human being, and we shall come back to what that means. It must be under the king's peace. So this excludes enemy combatants in wartime, and crucially, you need that specific intent. Each of these elements has to be proven beyond reasonable doubt. Miss one element and it's not murder. It might be manslaughter, but not murder at all. So actus reus of murder. So let's dig into it. The physical element of murder. There are several distinct components here, and each one matters. First, unlawful killing. The killing must not be justified or excused by law. So killing in genuine self-defense are lawful. Certain acts by state officials like soldiers in combat or historically executioners might be lawful, but not killings unlawful. If it is beyond that, it is unlawful. Second, causation of death. We need to apply those causation principles from chapter 1 that we have discussed. I hope you remember but for test. For factual causation, remember? But for defendant's act, would death be occurred? And then legal causation. Was the defendant's act an operative and substantial cause? Medical treatment that goes wrong usually does not break the chain of causation unless it's so independent and gross that it becomes real cause. Third, the victim must be a human being. This raises some tricky questions. When does life begin? When does it end? So a fetus is not considered a separate human being until it's born and has an independent existence. And that is now determined by brain stem death, not just when the heart stops at that point. Finally, under the King's Peace, this just means in normal circumstances, not during warfare. Oh, and one thing, the old year and a day rule has been abolished. You used to need deaths to occur within a year and a day of the fact, or the act. But modern medicine made that obsolete at that point. So it's gone. So what is mens rea for murder? For murder, one needs intention to kill or intention to cause GBH, grievous bodily harm. That's really serious harm. Notice that you don't actually need to intend to kill to be guilty of murder. Intending really serious harm is enough. Intention comes into flavors, direct and oblique. Direct intention is straightforward. It's one's aim or purpose. If one shoots someone in the head intending to kill them, that's direct intention, and that's very simple. Oblique intention is trickier, and we have talked about it. This is where death or GBH is not the aim, but it's virtually certain consequence of what the person is doing. And they appreciate the fact. The key case here is Wolin. Think about someone who sets fire to house to claim insurance, knowing people are sleeping inside. They don't want to kill anyone, but death is virtually certain, and they know it. That is oblique intention. The key case we need to understand is Vickers. Both establish that intent to cause GBH is sufficient for murder. And here is something crucial. Recklessness is not enough for murder. You cannot be reckless as to murder. You must intend either death or GBH. This is a really common exam mistake, so remember it. So the next thing is partial defenses that we can have. So we have got murder, but English law recognizes that sometimes, even though someone has killed with intent, there are mitigating circumstances that make them less culpable. That's where partial defenses come in, and partial defenses don't acquit the defendant, but reduce liability for murder to voluntary manslaughter. This is huge because it means avoiding the mandatory life sentence and allowing the judge to impose a sentence that reflects the true circumstances. So there are 4 partial defenses. First is loss of control, where someone kills after losing control due to fear or anger. Think of someone who has been abused for years and finally snaps. Second, diminished responsibility, where defendant's mental functioning was abnormal due to recognized medical condition. This might be severe, like depression and other mental conditions. The third is suicide pact, where people agree to die together and one survives. Pretty rare in practice. And fourth is infanticide, where a mother kills her infant child while the balance of her mind is disturbed due to childbirth at that point. This recognizes the very real impact of postnatal mental health, issues at that point. So these defenses exist because the law recognizes that not all intentional killing are actually equally morally culpable at that point. So context of that act or event matters. Loss of control. Let's talk about it. So this defense is governed by the Coroner and Justice Act 2009, which replaced the old common law defense of provocation. The act requires proof of 3 elements, and you need all 3. First, loss of control. The defendant must have actually lost self-control at the time of the killing. Now, here is something important. The old law requires the loss to be sudden at that point, but that requirement has been removed. Why? Because the law now recognizes that loss of control can develop over time, particularly in cases of domestic abuse where there is cumulative provocation building up over months or years. Second, qualifying trigger. The loss of control must be caused by one of 2 specific triggers that we shall discuss in the next slide. Third, objective standards. Would a person of the defendant's sex and age with a normal degree of tolerance and self-restraint have reacted in the same or similar manner? This is to exclude people who just have higher triggered temper. This is not temper, this is objective test, how other people will behave in those circumstances. The removal of sudden requirement was a really significant reform and represents the law catching up with our understanding of how domestic abuse affects people. So let's talk deep into loss of control and what are the qualifying triggers. So the number 1, the first and foremost, is fear trigger. The defendant feared serious violence from the victim against themselves or another person. This recognizes defensive killing that don't quite meet the full requirement of self-defense. Maybe the response was disproportionate, but there was genuine fear of serious violence. So it can be disproportionate, but they were under fear or threat. Number 2 is anger trigger. Things said or done constituted circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged. That's what you need to understand. So the threshold here is high. We are talking about truly grave circumstances, not everyday annoyance and all. So now here is something controversial. Sexual infidelity is expressly excluded as a qualifying trigger. Parliament did not want the defense to be available to jealous partners who kill. But in the case of Clinton, the Court of Appeal, not Bill Clinton, in the case of Clinton, the Court of Appeal said sexual infidelity can still be considered as part of overall context, even though it can't be the trigger on its own. One more thing, the defense is unavailable if the defendant acted in a considered desire for revenge. Revenge negates the loss of self-control, is the opposite of losing control. So the next thing is diminished responsibility. The defendant, and that comes from one of the core defenses. The defendant must prove 4 elements, and here is something important. The burden of proof is on defendant, on the balance of probabilities. This is one of those rare exceptions to the general rule that prosecution proves everything. Element 1, abnormality of mental functioning. The defendant's mental state must have been abnormal at the time of the killing. This is broader than just mental illness. It includes a wide range of conditions. Element 2, recognized medical condition. That's very important. The abnormality must arise from a recognized medical condition. We are talking about conditions that appear in established psychiatric classification system like ICD-11, DSM-5, that's terminologies, but this could be depression, schizophrenia, PTSD, and personality disorder, and many others. Element 3, substantial impairment. The abnormality must substantially impair at least one of 3 things: the ability to understand their conduct, form rational judgment or exercise self-control. So substantial means more than trivial, but does not have to be total at that point. Element 4 is causal explanation. The abnormality must provide an explanation for the defendant's conduct in killing. There must be a connection between them. The case here is Ryan, which established the broad scope of what counts as abnormality, and at that point this is clarified that intoxication does not automatically preclude the defense if there is an underlying condition. So that's what we need to understand. Suicide pact. It's amazing. It used to happen, it can happen, but those are very rare. So suicide pact is governed by Section 4 of Homicide Act 1957. If two or more people agree to die together and one kills the other, the survivor can be convicted of manslaughter rather than murder. The key is that there must be a settled intention to die or genuine pact. This reflects reduced culpability where the defendant intended to die alongside the victim. Infanticide is governed by Infanticide Act 1938, where mother kills her child under 12-month-old, like child should be under 12-month-old, whilst the balance of her mind is disturbed by childbirth. At that point, she may be convicted of infanticide rather than murder. Another thing, and let's talk about involuntary manslaughter. So this is completely different from the partial defenses we have just covered. Involuntary manslaughter is where the defendant causes death but lacks the mens rea for murder. They did not intend to kill or cause GBH, but their conduct is still efficiently or sufficiently culpable that they should be liable for causing death. There are three main types: unlawful act manslaughter, gross negligence manslaughter, and corporate manslaughter. So unlawful act manslaughter is where death is caused by an unlawful and dangerous act, like think of a punch that goes wrong. Gross negligence manslaughter is where death is caused by gross negligent breach of duty. Think of a doctor who makes catastrophic error and the person dies. And corporate manslaughter is organizational liability of management failure causing death, in that organization. So let's talk about unlawful act manslaughter. It is also called constructive manslaughter that requires three elements. First, an unlawful act. The defendant must commit a criminal offense. Civil wrong is not enough. The case of Franklin established that the act must be unlawful in itself, not just because it causes death. Second, dangerousness. The act must be objectively dangerous, meaning all sober and reasonable people would recognize it as exposing others to the risk of some harm. The key case is church case. Note that the risk is of some harm, not serious harm or death. The test is objective. We are not asking what defendant was thinking about it, but what reasonable people would recognize. Third is causation. The unlawful and dangerous act must cause death. Apply your standard causation principle here. So what's interesting, the defendant does not need to foresee any harm at all. As long as the act is objectively dangerous, that's enough, and the unlawful act must generally be directed at the victim or at the property. The case of Lamb illustrates it. So in Kennedy's case, the House of Lords dealt with drug supply case and held that where the victim self-administers drug, the supplier does not commit unlawful act manslaughter unless they actively participate in the administration at that point. So just providing drugs does not mean they have done unlawful act manslaughter. So the next thing that we got is gross negligence manslaughter. Let's learn about it. So it got 5-stage test from the case of Adomeko, like we got a case. Number 1, duty of care. The defendant owed the victim a duty of care under ordinary negligence principle. This is borrowed from tort law. 2, breach of duty. The defendant breached that duty through their conduct or omission. 3, risk of death. The breach must have created a risk of death, not just serious injury. This is crucial. Risk of mere injury is not enough to prove it. 4 is causation. The breach must have caused death. 5 is grossness. The breach must have been so bad that it amounts to a criminal act or omission, justifying conviction. This is key element. We are not talking about ordinary negligence. We are talking about negligence so bad that it becomes criminal. The assessment is objective, and it's for the jury to decide whether the negligence crosses that threshold into grossness. The test has been criticized as circular, but case like Misra has confirmed is sufficiently certain to just satisfy human rights requirement. This often comes in medical cases, but it's not limited to doctors. Anyone who owes duty can be liable under this. So let's talk about corporate manslaughter. The Corporate Manslaughter and Corporate Homicide Act 2007 created a specific offense for organizational liability where death results from management failure. The offense requires 3 elements. First, management failure. The way the organization's activity were managed or organized must amount to a gross breach of a duty of care owed to victim at that point. Second, senior management involved. The breach must be attributable to how activities were managed by senior management. We are talking about people who play significant roles in decision making. Third, organizational liability. Only organizations can be convicted under this act. Individuals cannot be prosecuted under it, though they might face separate charges of gross negligence manslaughter. The penalties include unlimited fines and publicity orders requiring the organization to publicize its conviction. This act was introduced because it was really difficult to prosecute large organizations under common law principles, specifically after the disaster in case like Herald of Free Enterprise and Paddington Rail crash. The act focuses on systematic failures rather than trying to pin everything on individual culpability at that point. So non-fatal offenses, we have already talked about someone died. Now we talk about non-fatal, where people did not die, but of course they are hurt. So that's the second part of today's session, this session. So we have condensed everything in order to not haunt you that there is load of content in it. So let's move on to non-fatal offenses against the person. This is still the offenses against the Person Act like 1861, and that is Victorian law, as we have talked before. So the act establishes a hierarchy of offenses based on the seriousness of harm and the defendant's mental state from least to most serious we have. Common assault, just causing apprehension or applying force, not actual injury required in it. Section 47, assault, occasioning actual body harm where the result causes some injury, one step up. Section 20, wounding or inflicting grievous bodily harm, more serious injuries with the lower mens rea requirement. And section 18, wounding or causing GBH with intent at that point, the most serious non-fatal offense requiring specific intent here. So the next thing is understanding this hierarchy, and that is very important because charging decisions depend on the severity of injury and the defendant's mental state. Prosecutors need to pick the charge that best reflects the culpability and harm. The Act has been heavily criticized for using archaic language and creating illogical distinction, but reform attempts have failed. So this is what we have at the moment in United Kingdom. So start from common assault, go to ABH, actual body hurt, then section 20 GBH and section 18 GBH. So all of it, those are different for our understanding. Let's start from assault and battery. Assault and battery are actually two distinct common law offences, though they are often charged together. Assault is causing the victim to apprehend immediate unlawful violence. No physical contact is required. If I raise my fist and make you think I'm about to hit you, that's assault. Words alone can constitute assault. The case of Ireland established this with silent phone calls, like, call and keep silent. The mens rea is intention or recklessness as to causing that apprehension, calling and keeping silent at that point. The next thing is battery, is the application of unlawful force to another person. This does involve contact, but the slightest touching offenses, like, that is sufficient. It does not have to be violent or cause injury. The case of Collins confirmed this. Even touching someone's like clothes can be battery. The mens rea is intention or recklessness as to applying force. Interestingly, battery can be committed by omission, where there is a duty of care. The case of Fagin is the classic example. The defendant drove into a police officer's foot and then refused to move. The court treated this as committing act of battery, that why you are not moving away at that point. Both offences are summary only and carry a maximum of 6 months imprisonment. Let's go to the next one, ABH, actual body harm, under section 47. So ABH is any hurt or injury calculated to interfere with health or comfort. So it can be very trivial, very small even, like, So we are talking about bruises, scratches, minor cuts, but also psychiatric injury, provided it's recognized under clinical conditions, like at that point. The case of Chan in Ireland confirmed that psychiatric harm counts. Even momentary loss of conscious is ABH at that point. So what's really important about section 47 ABH, the mens rea? You only need intention or recklessness as to the assault or battery, not as to causing ABH. The cases of Savage and other cases establish that. So even if you did not intend to foresee the injury, if you intended the assault and injury and that resulted, you are liable under section 47. This creates what called constructive liability. You are liable for more harm than you foresaw. So section 47 is triable, like either way, and carries maximum of 5-year imprisonment, bit more. So the next is wounding or GBH, like inflicting like grievous bodily harm under section 20. So examiner, they trick you between understanding section 20 and section 18, and we will try to make it easy for you. So let's define the term. A wound requires a break in continuity to the whole skin, both the dermis and epidermis. Both of them, they must be broken. Internal bleeding or a broken bone without breaking the skin does not count as wound. GBH means really serious harm. It must be serious, but does not have to be life-threatening or permanent. Psychiatric injury can be termed as GBH. The mens rea is when section 20 gets interesting, like, maliciously requires intention or recklessness as to some harm. not necessarily serious harm. The case of Mowat establishes this principle. So the defendant does not need to foresee a wound or GBH. Foresight of some physical harm is enough in Section 20. This is what distinguishes Section 20 from Section 18. Section 18 requires intent to cause GBH specifically. Section 20 has a lower mens rea threshold. So Section 20 is triable either way and carries a maximum of 5 years, the same as Section 47, sentence in it. The next is the most serious, and that is Section 18, GBH. The actus reus is the same as Section 20, wounding or causing GBH, but the mens rea is completely different and much more serious. There are two routes to liability. Primary route requires intent to cause GBH. This is the standard case. Deliberate infliction of serious violence. Recklessness is insufficient. The prosecution, they must prove the intent here, not recklessness. The alternative route applies where the defendant intends to resist or prevent lawful apprehension or detention at that point. So if you are resisting arrest and you cause GBH with intention or recklessness as to some harm, that's also Section 18, because at that point law makes it a bit more sensitive. So the heightened mens rea requirement, that specific intent, is what distinguishes Section 18 from Section 20 and justifies the dramatically higher maximum sentence. Section 18 carries a maximum of life sentence even. So Section 18 is indictable only. That's what you need to understand, and it must be tried in Crown Court. Exam tips. I know this slide is a bit more overpopulated, but I will try to make it easy and I'll try to explain it. So number one, don't confuse the mens rea for Section 18 and 20. Section 20 needs intention or recklessness as to some harm. And Section 20 needs that one. And Section 18 needs intent to cause GBH. Number two, always remember causation in homicide question. Apply both factual and legal causation. Consider intervening act and pre-existing conditions as well. Three, get the loss of control trigger right. Sexual infidelity alone cannot be qualifying trigger, but Collinton says it can be part of the overall things and all. 4. Remember that recklessness is never sufficient for murder. You must prove intent to kill or cause GBH. Number 5. Structure your answer properly. Always work through actus reus, the mens rea, then defenses. Apply the law to the fact and then try to get the answer. And I wish you all the very best. I hope it works for you in your SQE1 exam. And if you like this session, hit the subscribe button once again and share it with your friends. Ta-da for today.